Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. My name is Eric Nyman, and I'm delighted to be sitting today with my colleagues and friends, Justice Vicki Henry and Justice Kenneth Desmond. And this is the December 8th, 2020 sitting of the Massachusetts Appeals Court. And we'll call the first case, which is Commonwealth versus John Lincoln, case 2020 P0091. Both sides, as I've already informed you, you have 15 minutes to present your arguments. Usual appeals court rules are in effect, so there is no rebuttal. And we will hear first from counsel for the appellant.
Thank you, Your Honor. Members of the panel, may it please the court, Elizabeth Moan on behalf of the defendant appellant, Mr. John Lincoln. The crux of this case is the prejudice that was caused by the lack of jury instruction on non-deadly force in self-defense. This is a due process issue. The Commonwealth has a burden to prove every element of an offense beyond a reasonable doubt. And any jury instruction that lowers that burden of proof violates due process. The difference between the deadly force and non-deadly force instruction is significant based on the level of fear at which a defendant is allowed to act. Someone is allowed to act in self-defense based on a certain level of fear. That changes whether or not that person uses deadly or non-deadly force.
Attorney Moan, is there any dispute, or is it your client's position that the alleged victim in this matter picked up a weapon and threw it at him? Is that accurate?
I believe it's that they swung it at him, but correct. So there's no question that Mr. Lincoln alleges that Mr. Raymond used a dangerous weapon. But in this case, there is room for the jury to believe that Mr. Lincoln had a reasonable fear for his safety, but did not necessarily rise to the level of fear of death or great bodily harm. And Mr. Lincoln even testified that this was a quick reaction, that he was just coming out of the door, Mr. Raymond swung at him, and because of the bushes, he couldn't completely see. So I think under those facts, it would be reasonable for a jury to find that Mr. Lincoln had a reasonable fear for his safety, but not necessarily an actual and reasonable fear of great bodily harm or death. And the difference between those standards is where the prejudice lies in this case. If the jury had...
Before you get to prejudice.
Yes, Your Honor.
Quoting from the model jury instruction, the Commonwealth for non-deadly force is required to prove that the defendant did not reasonably believe he was being attacked or immediately about to be attacked, and that his safety was an immediate danger. I think I correctly read that instruction.
I believe so.
At the trial transcript, page 213, the trial judge instructed, and I'm quoting, "A person cannot lawfully act in self-defense unless he is attacked or is immediately about to be attacked," end quote. That portion of the instruction seems to parrot the correct non-deadly force instruction. So why is that not sufficient? Because
the jury was instructed that it's the and that his safety was in immediate danger. The jury was instructed that the defendant must have immediate danger of great bodily harm or death. So
in the portion of the instruction I just read, you're correct that the judge did not say that his safety was in immediate danger, but that should inure to your benefit or to your client's benefit.
In that case, that's a supplement. I believe that's the supplemental instruction. And so that is in addition to the instruction that the Commonwealth only has to disprove that Mr. Raymond was in fear of death or great bodily harm. And I think this is in contrast to Commonwealth v. King, in which it was to the defendant's benefit that the judge issued an errant instruction. And the difference between this case and King is that there was no instruction saying the Commonwealth could disprove self-defense by disproving a certain level of fear. So the judge had removed that from the Commonwealth's arsenal, so to speak. In this case, the judge had specifically instructed the jury that the Commonwealth could disprove self-defense by proving that he did not have a fear of great bodily harm or death. And it should have been they could only disprove self-defense if he did not have a fear of his personal safety.
Was there an objection in King to the instruction as given?
I don't remember if there was an instruction in King, an objection in King.
Here's my concern, because I agree with you that the judge, at least in part, gave the deadly force instruction rather than non-deadly force. The issue is there was no objection to the instruction. And then at transcript page 213, the language I read you really parrots the correct portion of the instruction. And it's quite possible that defense counsel, upon hearing that, said, well, that's the language that is of concern here. The judge stated it, so I really don't need to object because that came across correctly to the jury. The absence of an instruction here makes this a more difficult case, the absence of an objection, rather.
I agree that the absence of the objection makes this more difficult, and I believe that's why we are in the land of substantial risk of miscarriage of justice. But if we look at Commonwealth v. Freeman, that was a case in which there was, they said that an error of this type and seriousness would still lead the court to reverse. And it's akin to Commonwealth v. Beaudry, which is actually cited in the Commonwealth's brief. In that case, trial counsel objected to a closing argument, but then agreed to a curative instruction, and the court still reviewed it because these errors are so serious, we can't allow them to exist simply because counsel didn't object. As a more practical reason, then everything would simply become an ineffective assistance of counsel claim. So this court does have a long history of considering waived errors under the substantial risk of miscarriage of justice standard. I would disagree with the court's characterization that the supplemental instruction parroted the language in question because it's really that level of fear that's the issue. Mr. Lincoln was entitled to act in self-defense if he had reasonable fear for his safety, and at no point did the judge instruct that. And he instructed them that he could only act in self-defense if he had fear of great bodily harm or death. And the supplemental instructions even repeat that errant standard.
So on that same transcript page of 213, after the text that Justice Nyman quoted, it seems like the judge, the way the transcript reads, it's like it's garbled or a little bobbled, because the Commonwealth may prove that the defendant did not act in self-defense by proving beyond a reasonable doubt that there was no overt act, either words or a gesture, or some other action that may give rise to a reasonable belief of attack or immediate. So that picks up what Justice Nyman read. But here's the problem. Then it says, or reasonable belief of attack or immediate dash dash or attack or of great bodily harm or death. What is that language? How does that language affect your argument? And he continues actually that a person cannot lawfully act in self-defense unless he has exhausted all other reasonable alternatives before resorting to force. Is that also in the non-deadly instruction, or is that limited to deadly force?
That's also in the non-deadly instruction. So there are essentially three ways that the Commonwealth can disprove self-defense. The second and third are identical in the deadly force and non-deadly force instruction. And that is not using more force than necessary and doing everything reasonable in the circumstances to avoid physical combat. The only place that these instructions differ is on the level of fear that entitles the defendant to act in self-defense. The part that is, it is admittedly not perfectly delivered, but that part that you just highlighted is in fact the addition to the supplemental instruction for deadly force. So that is where the judge reinforced this higher standard that he has to believe a reasonable belief of attack or of great bodily harm or death.
Is it common sense to believe that when somebody swings a brick at you, that you're in fear of imminent bodily harm?
Yes, I believe so. I think the issue in this case is whether the jury had to believe that Mr. Raymond was in fear of great bodily harm or death. And on the facts of this case where Mr. Lincoln said it was a quick reaction, he couldn't really see, I do think the jury could have found that he was in fear of his safety, but not great bodily harm or death.
And where do you point to where it says he couldn't really see? When I read his testimony, he says that he came up and the gentleman swung a brick at him, that he missed him, and that's when he punched him in the face. And I'm looking at page 166 of the transcript.
I'm also looking at page 166 of the transcript, line 7. He says, it was a quick reaction because you couldn't see around the bush. The bush was thick enough so when you walk, you can't see. So I believe what he's describing is as he's coming out of the door of the garage, there is a line of bushes to one side.
But then he goes on, line 14 of that same page. He says, when he fell forward, that's when I hit him, when he missed with the brick. So, yeah. So I'm not sure how he couldn't see around the bushes plays into that portion of his testimony.
So this is not a clear case. It's not completely clear why the jury found him guilty of assault and battery. And that is the issue. It's possible that they could have found that he did not retreat or another reason that he did not act in self-defense, but we don't know. And that is the prejudice in this case, that we don't know if given the proper instruction, they would have found that he was in reasonable fear of safety, but he was entitled to that instruction, and we can't be left to guess why the jury found him guilty and if they were given this instruction, if they would have convicted or acquitted.
Is your A1 best case or cases for the proposition that this specific error constitutes a substantial risk of a miscarriage of justice? What are the best parallel cases factually?
The best parallel case is Commonwealth v. Noble. That's the case where the defendant had the victim in a headlock, and the court found that if there is a question of fact of deadly versus non-deadly force, then both instructions must be given. And it also found that the lack of instruction did create a substantial risk of miscarriage of justice because the defendant was denied the jury's consideration of his defense. So it's not that the jury would have found him not guilty, but that the jury was not able to consider his defense. And in this case, where Mr. Lincoln testified that he did strike Mr. Raymond, there's an incredible prejudice to him not being allowed to present to the jury the defense to which he testified.
On the other issue, the Commonwealth argues that the prior interactions between Raymond and the defendant were admissible to negate the claim of self-defense. What do you say to that?
Commonwealth v. Adjutant sets out very specific rules for how someone can rebut that type of evidence. The Commonwealth has to give notice to the defendant, and that didn't happen in this case. There's also a difference between prior bad acts and propensity evidence. The court has been cautious, even in properly admitting prior bad acts, to not bring someone's reputation into the courtroom. And these are not specific acts like the incident with the putty knife that would explain the relationship between the parties. These are general statements. We don't know why he thinks this. We don't know where he's getting this information. This is pure reputation evidence that is brought to the detriment of Mr. Lincoln. I see that my time.
You may have answered this, but I know that you indicated there was no objection to the instruction. Was there a specific request for non-deadly force instruction?
There was a specific request. There was not a specific request for the non-deadly force instruction. I do see my time is running out, but I would like to finish answering this question if the court would allow.
Yes, please do. Thank you for asking.
Thank you. The conversation about this instruction is quite unusual because all of the parties agree to give the instruction on errant evidence. But I do think if we look to cases like Freeman, we will see that that does not prohibit this court from taking this issue on the substantial risk of miscarriage of justice standard. On that, I will rest on my brief. Thank you.
Thank you. Let me just check with the other panel members. Any further questions? Okay, thank you. We will now hear from the Commonwealth.
Thank you, Your Honors. May it please the court. Carrie Kohler for the Commonwealth. My apologies again for the internet situation. I would submit to the court that this case is really about determining whether the defendant had the benefit of a fair trial. Since the instructional error issue is not preserved, the court is evaluating whether there was a substantial risk of a miscarriage of justice. I would, with respect to Commonwealth v. King, that objection was unpreserved. I submit it's a similar case procedurally, although not substantively, in that it was an assault battery by means of a dangerous weapon, where the conviction was for the A and B, and the instructions were erroneous. In Mr. Lincoln's,
the defendant has pointed to Commonwealth versus Noble as, the key case, and having read that case, it certainly is a compelling case for the defendant. Why does that not compel us to reverse here?
I suggest that Noble isn't helpful in this particular fact set because the degree of force wasn't the degree of force was at issue, but the kind of force was not. And it is parsing it very closely. So in Noble, the fact that the defendant used a chokehold wasn't in dispute. He admitted to that. But the SJC was particularly concerned with whether the jury was able to properly evaluate the degree of force utilized in that chokehold. I would submit that in this case here is distinguishable from that, because the failure to give the non-deadly use of force instruction in Noble really did create a problem where the court was left to wonder whether the jury was able to consider Mr. Noble's defense to the murder charges that he faced. I submit here that the jury was able to properly consider self-defense, both to the assault and battery by means and the lesser included. In the light most favorable to the defendant, he was faced with lethal force. And while that's not the end of the story and certainly not how the instructional decision should have been made, I would suggest that the defendant had the benefit of presenting his self-defense theory. In the light most favorable to him, he was entitled to use force up to and including lethal force. So here, the brick that the victim was swinging at him in his version presented was very harmful to him. I submit that
Right, but the defendant's point is that, and this is what Noble speaks directly to, and I'm quoting Noble, it says the judge's instructions remove from the juror's consideration the issue whether the defendant used non-deadly force in response to a reasonable fear for his safety. And it was that error that substantially undermined the defense. And that's what this defendant here is arguing.
Yeah, I understand
either
that.
something here on page 213 has to address that, or it seems like Noble compels us to reverse.
Right. And I see Your Honor's point, which is why the Commonwealth's primary argument that it's set forth in its brief is really about the instructions being given as a whole. I don't disagree that there were better ways perhaps to deliver the instructions, but relying on those pages, the reasonable apprehension of force instruction, as well as the discussion of excessive force and how the Commonwealth can disprove self-defense, I suggest that when you take all of the judge's instructions together, that it compels this court to find that there's not a substantial risk of a miscarriage of justice.
So what in the transcript pages, what is the language that you think satisfies the concern that the HBC had in Noble?
I would submit what I kind of referred to as the reasonable belief set of instructions, the 213 through 214, Your Honor. I would submit that what I believe my sister referred to as the supplemental is what gives the jury the ability to really weigh the proportionality of the defendant.
What lines here on those pages?
I would suggest that the court, particularly beginning on page 2, a person cannot lawfully act in self-defense unless he is attacked or is immediately about to be attacked. The Commonwealth may prove that the defendant did not act in self-defense by proving beyond a reasonable doubt that there was no overt act, either word or gesture, or some other action that gave rise to a reasonable belief of attack or immediate or attack or of great bodily harm or death. I would also say the other possibilities of the Commonwealth defeating that give the jury the opportunity to evaluate the proportionality of the defendant's conduct. A person may use physical force in self-defense only if he was not able, or I'm sorry, only if he could not get out of the situation in some other way that was available and reasonable at the time. I think taking that together with the erroneous, well, the exclusive, I don't think it's erroneous, exclusive deadly force instruction, they don't, simply because we're calling it a supplemental instruction doesn't make it any more or less important to the jury. And in fact, His Honor specifically instructed the jurors that they were not to give any particular instruction any more or less weight. And I would submit to the court that even though it's certainly inelegant and it's not what we're used to seeing and what's preferred under the model instructions, that this language of reasonable belief really gives the jury the tools that they need to legally decide and evaluate the defendant's self-defense. That they convicted of the lesser included, I would not suggest is indicative that the instructions were so in error that they carried a substantial risk of a miscarriage of justice.
So
did I answer Your Honor's? Yeah.
Go ahead. Well, it seems to me that you're arguing essentially, I'll start again. It seems to me that you're arguing that the instruction was wrong in part, but parts of it were correct, and so it's good enough. And is there any case law that guides our analysis in that regard? That is, are there any cases in which the instruction has been held to be correct in part, incorrect in part, and explain to the court how to evaluate that kind of situation?
There's really not. I was unable to locate something that was very helpful. I concede that this is a very concerning instance when it happens. The majority of published cases that deal with this particular issue of deadly versus non-deadly force, when the non-deadly force instruction is excluded and the deadly force instruction is given, where the defendant advances a theory of being faced with a variety of forces and responding with non-deadly force, seems to result in reversal most of the time. Commonwealth v. King is one of the few instances where it's not. There was a 128 from 2018 that I didn't cite, Baez, 93 Mass Appeals Court, 1119, but it was unpublished. Was a little bit similar, but I would concede that the majority of cases are not in favor of the Commonwealth's argument. Abu Barter.
So you've anticipated. Yes. I'm sorry, you've anticipated my next question, which is in terms of published cases, what is your best precedent or an affirm on this issue?
I submit that it's Commonwealth v. King, Your Honor. And I would seek, and I believe I did in my brief, distinguish the cases cited. And I'd submit to the court that Noble is distinguishable in this case, given that Mr. Lincoln's case and the Commonwealth case were very at odds with each other. Mr. Noble's case, I'd submit, was a much closer call. So I would submit that. And
you had indicated earlier in your argument that when we're evaluating the instructions, we're looking at the evidence in the light most favorable to the defendant. So that would say that he just used his fist, his hand, right?
I'm sorry, Your Honor, I lost the last part of your question.
Well, you had indicated earlier we review the evidence in the light most favorable to the defendant, which means that he used only his hand rather than a weapon, right?
Yes, Your Honor.
And so normally that would require the non-deadly force instruction.
Yes, Your Honor. So I suggest that even in this particular case, the Commonwealth's best argument for that problem would be that though the judge's instructions did not track the model instructions, that they incorrectly excluded the non-deadly force supplement or portion of the self-defense instruction, that the additional supplemental instructions that he gave, as well as that set forth the reasonable belief and how a defendant can respond when faced with force, I'd submit that properly puts before the jury the defendant's theory of self-defense. And I'd also submit that given the strategy, given the theme and story of the defendant's case, that the failure to give the particular non-deadly force instruction did not create a question, I would submit that justice was not done in this case, that the jury was unable to reach a fair and lawful verdict.
So you're essentially, go ahead, Judge Henry.
No, I was going to switch to the other issues, so let's finish up this one.
I'm good.
Okay.
The defendant argues that you couldn't, there's this issue about Mr. Raymond saying the defendant was a nut. How was that testimony possible? And bear in mind the adjunct question.
Right. I submit to the court that as far as the adjutant and adherence to the protocol, I don't think the record's factually developed enough. And I think with respect to that particular line of, well, he's a nut, I think was what the victim, or what the Mr. Raymond said. That particular statement, I think it was elected tactfully. I think you can read into a lot of what was admitted was part of defense counsel's strategy in undermining Mr. Raymond. He essentially let him talk and testify about all kinds of things, and then completely undermined him with a really powerful moment of advocacy. And I think that the impeachment process that counsel went through was successful in legally undermining the victim's credibility. I'd submit to the court that there's definitely a circumstance where trial counsel is faced with objecting and challenging testimony one way and essentially waiting and letting it play out another. I think the other potential explanation for why counsel did not object, which is hard to come up with because there really isn't a factual record to get at it. So I'm reading in a little bit from an experienced defense attorney what their tact might be. But I'd suggest that there's probably a thought in there about how the defendant intended to introduce this relationship. These weren't two people who met on the street and had nothing to do with each other. There was a bit of a history there, and the jury is entitled to know a little bit of the backdrop and what's going on with these parties and what motives might be and what biases they might have. He's a nut really could have been utilized either way.
Attorney Kohler, your time has expired. I'll let you finish your thought. Go ahead.
I was all set with that thought, Your Honor.
Okay.
I'm happy to wrap on my brief. Apologies again for the internet. Thank you.
No need. Let me just check with the panel. Any further questions, Justices Henry and Desmond?
None here.
Okay. Thank you both for your excellent briefs and your excellent oral arguments. It's much appreciated, and the case is submitted.
Thank you, Your Honor.
I'm Eric Nyman, and I'm delighted to be sitting today with Justice Vicki Henry and Justice Kenneth Desmond. And our next case is Commonwealth versus Molina, docket number 2019 P1751. We will hear first from counsel for the appellant, Mr. Molina. And Attorney Oren, you are on mute right now. So.
Attorney Oren, I believe if you press *6, you can unmute yourself.
Does that work?
That does work.
Okay, so sorry for, I am just a technological idiot. I apologize. Catherine Oren for Jamal Molina. And if I can have roughly 3 minutes, please. Suppression error here was that simple. Why did police criminally suspect the young black man in this case? On police concession, that happened because he briskly walked takeout to a parked car. He didn't enter the roadway to speak to the officer who chanced to stand idling at a red light. He turned rather away towards the parking lot where his dad's car waited. Police suspected crime. So young black men get takeout every day. When that happens, pace quickens alongside appetite. And even the suspicious officer stated no reason why any hungry diner would enter a roadway to address chance motorists. Criminal suspicion was groundless. Nor did the court wrongly find no obscure plate just because its bottom rim was slightly bent. The plate was conspicuously displayed on the car's rear. All letters and numbers were fully open to view. No obstruction, blockage, or obstacle obscured plain view information. Police indeed admitted the momentary problem was external. Reflected streetlights had fleetingly delayed reading plate data. And even that problem was so momentary, it took all of 30 yards, less than a third of a football field, to read the plate, light cruiser lights, and stop the car. The court was not wrong in finding that stop legality thus reduced the belief that the young man had been in a brawl 4 days before. And that's because his dad's car had been reported as possibly used by undescribed brawlers. Police, though, knew the car was shared.
Counsel,
The 911, yes.
once the officer reads the license plate and realizes that that car had been used to get away from the brawl, was there reasonable suspicion at that point to stop the vehicle?
No, there wasn't, and here's why. He knew that the car was shared because the 911 caller had seen 3 men use it. And he knew further that the car's registration, he had had the car's registration information for 4 days. And that includes the owner's name and date of birth. And that's inconsistent with this plainly young man getting takeout 4 days later. And
Because
he didn't
the
know
car was registered in the father's name?
Yes, yes.
And
And
when
so-
you say that
and-
the police knew it was shared, that's because, it's not because 3 people used the car. Like, that doesn't mean 3 drivers used the car, right?
No,
You're just saying
inferentially,
that-
only one was driving. It was used by 3 men, right? That's what the 911
But
caller
you're-
reported. And police knew that the car.
So,
yes,
but you're saying
go ahead.
it was shared because the police knew the age of the owner and they knew that the person who left the brawl was younger than that? Is that why they knew it was shared?
Well, they knew that more than one person used it from 2 different sources. And they knew that the owner was older, the date of birth inconsistent with this young man. They didn't know the young man at all, much less from any crime. All that officer saw was their use of a shared car several days after undescribed men had brawled. And that sustained no reasonable suspicion that the young man had ranked among them. Stop here didn't happen within minutes or even hours of crime. 4 days, rather, had passed, during which a knowingly shared car continued to be shared. And that reduced stop grounds to belated suspicion by association, though no witness associated the young man with anyone, much less criminal. So this was no close call, as the court claims. Police reflex rather birthed groundless suspicion, joined with hearsay-based assumption. And hunch-based overreach mandated suppression of all evidence stemming from that stop, and Molina seeks that remedy now.
But
I'm sorry to interrupt, but why is it a hunch when it's the exact same car that was used as a getaway vehicle, has the same license plate, same car? It's in the exact same area where the brawl occurred. And the defendant is also, as soon as he sees the police officer, immediately looks down, looks away, and moves quickly to his car. I know that as an individual circumstance, that factor is meaningless, but taken in conjunction with the other factors I listed, that doesn't strike me as a hunch. Those strike me as reasonable, articulable factors.
Right. Well, the hunch really is where he sees this kid coming out with takeout. Instead of walking into the roadway where this officer chances to be idling, he turns around and briskly walks the takeout to a parked car. And the officer suspects him of crime. That's why he starts following him. That's the hunch. And then joined with these claims, largely hearsay. The brawl victim's grandfather had made a bunch of hearsay-based claims that really were no more than idle gossip. And so the hunch, he saw the kid walking away. He suspects crime simply because the kid didn't address him. And just completely a mystery. Why would any hungry diner go into a roadway to address somebody who just chanced to pull up? Putting that together with 4 days before, we got completely undescribed brawlers. And yes, we have this possible plate, no 2 ways about it, and this seems to be the possible plate. It still doesn't mean that young man had anything to do with any of those men. In fact, according to the hearsay, it was a 28-year-old guy named Bomber. So this is what I'm getting at. And the hunch part for me, it really is. It's just a black kid getting a roast beef sandwich. That can't be mistaken for reasonable suspicion of crime. And that's what started this whole thing.
Well, the hunch, I'm going to just push back a little bit, because the reasonable suspicion has to be in place at the time that he stops the car, not at the time he decides to get behind it and just follow it along. And so
That's
and
right.
the officer, who's a 16-year veteran of the police department, attention was drawn to this young man who seemed to be acting suspiciously to him. And so he didn't stop him. He didn't approach him.
I mean,
He just followed along. I mean, what else would we want the officer to do? And then he gets behind him and he realizes, wait a minute, this is the same car that was reported as a getaway car in an incident that happened only days ago in the same area. So what would you have the officer do?
I mean, but I would understand that if there were anything criminally suspicious about walking takeout to a parked car. And the court just now said he was acting suspiciously, and that's why the officer started to follow him and then saw the plate. I just honestly cannot understand what about getting takeout 3 days after Thanksgiving and walking it to the car parked in the parking lot could reasonably deemed to be suspicious, much less reasonable suspicion under Terry, enough to stop the car.
I don't think that was the suspicious part. I think
And
the
so
suspicious
that's
part
the
was
hunch-based part.
I don't think that was the suspicion, him grabbing the roast beef and coming out of the restaurant. The suspicion was his seemingly trying to avoid the eye contact with the police officer.
So he turned his whole body away from the roadway toward the parking lot. So of course he's going to be looking towards where he's walking. Walking with his head turned around backwards would be objectively bizarre, and that would support reasonable suspicion that something's going on. That he sees a cop and he's scared enough that he won't take his eyes off the cruiser. Here, he's just taking takeout to a parked car, and it's just unreasonable of the officer. I can't think of even one reason. Why would anyone getting takeout go into a roadway and just start talking about people who just chanced to pull up at a red light? And that's just not reasonable suspicion. And so it is not suspicion at all, and that's the hunch part. And I understand that it was then joined with this knowledge once he saw the plate about this brawl 4 days before, but that can't cure it. I mean, it's just no reason to link this young kid with any of the guys that had been seen during the brawl and jumping into the car several days earlier.
What if this, let me give you a hypothetical, same essential facts, but 3 people are seen at the corner. There's a 911 call about a shooting at the corner of Smith and Jones Street. The shooter and other 2 assailants get into a car, Massachusetts license plate 1234. 4 days later, immediately adjacent to the corner of Smith and Jones Street, an individual sees a police officer, immediately looks away from the officer, moves quickly to the car, gets into the car, and the officer notices that it is the exact same car, exact same license plate that was the getaway car for the shooting 4 days earlier in the exact same location. Does the officer have reasonable suspicion to stop that vehicle?
Well, if all the guy did was look away from the police, that's one thing, trying to avoid eye contact. But here, we have somebody walking away towards the car.
Excuse me, Attorney Orrin, excuse me. And again, the hypothetical is, after the shooting, the individual, after looking away from the officer, moving quickly to the car, gets into, looking away from the officer, gets into the exact same car that was the getaway car for the shooting 4 days earlier in the exact same location where the shooting occurred. Is there reasonable suspicion or not under the hypothetical that I just gave you?
That would be a much closer question simply because there had been gunfire, right? And if you think 4 days later, unless there's some reason to think that the use of a borrowed car, a shared car, several days after the fact was actually involved in that shooting, walking takeout to a parked car, that just doesn't mean anything at all. And we arrived at a very dangerous place. We've been cautioned that it's potentially facts that would spotlight the possibility of some subconscious racism. I mean, a white guy walking takeout to a car wouldn't be a problem. But a young black kid, automatically the guy started following him, and that's what started this whole thing. And so, absent more information that would specifically link, 4 days later, this specific guy to a shooting, it would still be a problem. It's much closer in terms of analysis, but there still wouldn't be. So you would need more to link that person individually to the shooting 4 days earlier. I mean, there is a lot of case law where if there's a threat, an imminent threat to the public, that adds an edge to reasonable suspicion analysis. But when you've got a passage of 4 days, that I think that would affect the edge that would be added to the analysis by any shooting claim.
Okay, Attorney Oren, you have 3 minutes left. Any other aspects of the case you would like to present to us?
No, I think that everything else has been in the brief, and Melina, thank you for hearing him out this morning. He appreciates that.
Thank you. And let me just check with the members of the panel. Any further questions? No, thank you for your excellent argument, Attorney Oren, and we will now hear from the Commonwealth.
Good morning, Your Honors. May it please the Court, Monica Delatorre on behalf of the Commonwealth. The Commonwealth is respectfully requesting this Court to affirm the denial of the defendant's motion to suppress and motion to reconsider. Here, there are two alternative legal bases for the stop of the defendant's car. First, being reasonable suspicion that the car was involved in criminal activity, and second, because the defendant had committed a traffic violation. And I'll turn first to the legal basis of reasonable suspicion. There are 4 facts here that support reasonable belief that an operator of the defendant's car was involved in criminal activity. The first one being, as has been mentioned, the defendant's car was an instrumentality of a recent crime of assault and battery that involved a firearm that took place across the street from where the defendant was seen. And I would suggest that that fact is enough on its own to provide reasonable suspicion. I believe, as Justice Henry had noted as well. But in addition to that fact, we also have, as has been noted, that the defendant had acted evasively, had nervous behavior at the site of the detective's car. In addition, there was a bent and detached license plate that was difficult to read. The findings of the motion judge here was that the detective had to follow the defendant's car for a number of blocks in order to read the license plate. And this took place at
is it 30 yards or is it a number of blocks?
It's actually the finding of the motion judge was that it was across the street. Excuse me. The findings of the motion judge was that it was 100 yards, but that was incorrect in terms of the testimony. We had stated that that was an error in the findings of facts. It's the testimony at the motion hearing was that it was across the street. The 100 yards, that terminology of 100 yards had actually come from the police report that had been submitted on this case. But the finding, excuse me, that it took place across the street. From where the defendant was initially seen. In addition,
when you say it took place from across the street, you're saying he was stopped across the street?
So the testimony was that the initial, when the detective saw the defendant initially, it was across the street from where the assault and battery had occurred. He then followed the defendant sort of around the corner and a little bit further down to the right in terms of where the stop had occurred.
So how much distance would you say that he followed him before he was able to legibly read the license plate? That's my question.
Mm-hmm. The finding of the judge there is that it was a couple of blocks, that it took a couple of blocks in order for the detective to determine the license plate and then to recognize that that was the same car that had been a getaway car in an assault and battery a couple of days beforehand nearby.
And he indeed was able to read the license plate. He didn't need any flashlight. He didn't have to wait and get out of the car to read it. At some point, he was close enough where he could read it.
He does state that, yes. At some point, it took him a couple of blocks, but at some point, because of the way that the lights were flashing on the back of the defendant's car and license plate, he was eventually able to read the license plate numbers.
And so because of the way the lights were flashing, that's not a traffic violation by the operator of the vehicle, is it?
Well, I would suggest that the way that the license plate was bent in the fact that it made the officer have to go a couple of blocks in order to determine what those license plate numbers are, that would be a traffic violation in itself as a separate alternative basis to stop the defendant's car. I would.
With respect to that, I'm sorry to interrupt, but with respect to that argument, is the judge's determination that there was no traffic violation there a question of law, a question of fact, or a mixed question of law and fact?
I would suggest that that conclusion is a question of law, and we have contested that and suggested that it was an error and a legal conclusion. Chapter 6 of Section 90 requires that a license plate has to be displayed conspicuously. Here, where the detective had to go a number of blocks in order to read the license plate number, and where it was bent up, that's a violation of Chapter 6, and the defendant's car could have been stopped on that basis alone.
So anytime a license plate is bent, that's a motor vehicle violation?
If I would suggest if it's bent to the extent where the license plate numbers aren't illegible. There are a couple of unpublished cases that note that if a license plate, they're cited to in our brief, is perhaps at an angle where an officer has to turn his head in order to read license plate numbers, that would be a violation of Section 6 of Chapter 90. So it's not just that the license plate was bent, but also that it was bent in such a way that the license plate numbers couldn't be read.
What was the officer's testimony with respect to the license plate? I know he said it was bent, and he said he couldn't make it out initially. Did he explain why that was the case?
He did say that it was bent up, that he couldn't read the license plate numbers, and then added as well the testimony about the way that his light was shining on the car made it also illegible as well. In terms of the license plate reflected the light from the detective's car.
So is there any evidence in the record that the police attempted to question the owner of the vehicle in the 4 days between the brawl and the stop?
I don't believe there's evidence of that in the record. In terms of what had happened in terms of the 4 days, there's discussion of the detective going and interviewing the victim, interviewing the victim's mother, and interviewing the victim's grandfather. But I don't believe in the record there's any evidence of him running the license plate number. Indeed, it was unknown at the time of the stop that anybody else had operated the car. When eventually the detective ran the license plate numbers, that was when it was determined that the defendant's, father was the registered owner of the car.
Right. Well, and we have the Supreme Court decision of Kansas versus Glover that says the police can assume that the driver is the owner of the car. But here we have a youth who's inconsistent with the age of the driver, right?
I don't believe that's what, in terms of the defendant being a different age of the owner, that wasn't known to the officers before stopping the defendant's car.
He ran the plate. So when he ran the plate, doesn't he get the name and the date of birth of the owner?
Yes, that was the running of the plate was after the stop of the defendant's car, after the car had already been linked to the assault and battery and the number of factors that have been discussed.
So you're saying the detective saw the license plate, knew it was involved, and did not run it. At that point, he hadn't run it, didn't know who the owner was until after the stop.
That is my understanding, yes. So recognizing that he did not stop the defendant's car until the recognition of the license plate being the same as the assault and battery. But here's
the limiting principle on your argument. I mean, first of all, I don't know if the address of the owner of the car was also near the neighborhood, because most cars they spend most of the time near home. That's why most car accidents are within a mile of the house, right? So what's the limiting principle if the police officer runs the plate a month later, a year later? Like when would we say no, that's not reasonable anymore? Because right now what I see is that you could run it 5 or 10 years later. Car was involved with it was a getaway car. So we can stop whoever's driving it.
Well, I do think what is important here is that the crime was still actively under investigation, and that it was a relatively short period of time between the assault and the time that the car was seen. It was still being investigated by Detective Casales. As I mentioned, he had done these interviews as well. I think this all depends on the crime that's being investigated as well. Here, there was also a firearm, which is a durable good. It's not a narcotics case or anything like that.
That I don't understand, because you either have that urgency because there was a firearm, in which case one would think that a detective might have immediately gone to the owner of the motor vehicle. Like, I think our citizenry might be a little concerned that allegedly there was a gun involved, and yet we're taking a relatively leisurely approach to going and talking to the owner of the motor vehicle.
Unfortunately, I don't. Like I said, I don't have the testimony as in terms of the steps that the officer was taken, but I do not think that alters the reasonable suspicion here. As I mentioned, I do think those steps were taken. I will also note that the timeline here was relatively quick in terms of this assault took place on the Wednesday before Thanksgiving. The assignment of the case was to the officers on Thanksgiving, and it was the Sunday afterwards that the detective saw the defendant's car. Potentially, if there was a number of weeks or number of months where there wasn't as much investigation going on, I think that could be a different situation. Though I would note, this court has seen in the recent months. I will note the case of Commonwealth versus Smith, which is an unpublished decision of this court. I apologize, it's not in my brief. It was in October. It's 98 Mass Ep Court 1112. That in that case, 2 months was not too long in order to stop the defendant's car because the defendant had been had a recent violation of a license suspension, and that type of case or type of crime can have multiple months where you're violating a license suspension. And that court noted that it's different than a narcotics case where a narcotic can be traded or distributed or ingested. So I do think here that it's not that in terms of what the detective had done, it was appropriate here. It doesn't dispel that 4 days is not too long of a period of time.
So if we strip away all the other facts and we just have that the police officer is driving his vehicle and he gets behind another motor vehicle and he looks at the plate and he says, hey, that's the police, that's the plate of the car I'm investigating. That's it. There's no furtive look or look away in the parking lot. It's just that he sees the license plate and says, oh, that's the car I've been working on. On that alone, could he stop the motor vehicle?
I believe so, and particularly where it's in the relatively same location as the assault and battery as well. There's reasonable suspicion that an operator of the defendant's vehicle was involved in criminal activity, and it's reasonable for the detective to stop the defendant's car to confirm or dispel that reasonable suspicion. There's just one other quick note that I did want to state about the findings of facts, that in terms of the race and the age of the defendant here, that's not in the evidentiary record. It's also not in the findings of the fact as well. There's no evidence as to that, and indeed was not in the findings. I'm happy to answer any other further questions.
See if there are any further questions.
Well, you say on page 41 of your brief that the detective, I think you said, could search the vehicle because it was unknown whether another individual had access to the car. Do you see?
Yes. So that argument is in terms of the eventual admission of the firearm. I would just first note that the defendant has not contested that here. That has not been raised as an issue. And then also, in terms of the subsequent admission, there was a flashlight that was shining into the defendant's car, which was not a search, as well as this was pursuant to an inventory policy and would have been inevitably discoverable. We had also noted, in addition to those, I
guess my concern is whether this contradicts your earlier argument that the driver of the car was involved in the assault and battery. In other words, if multiple people had access to the car, does that raise a concern about whether there was reasonable suspicion to stop the car? Because you're basically saying there was reasonable suspicion to believe that the driver of the car was involved in the crime, but then you're saying, well, other people could have had access to the car.
To be clear, I think it's reasonable suspicion that an operator of the defendant's car was involved in the crime. It's not that there's direct evidence to this defendant, but the case law has shown that that is okay, that in terms of that there's reasonable suspicion of an operator of the defendant's car. So I don't think that diminishes that fact.
Well, but that's where I'm back to, it does seem like there's a darned if you do, darned if you don't element here. We have the United States Supreme Court saying the police can presume that the driver of a motor vehicle is the owner. And you're saying, well, no, we're not going to assume that for this case. For this particular case, we're going to assume always that the driver of the motor vehicle was the person who was involved in alleged criminality. So, I mean, it seems like this is maybe perhaps more of a criticism of the courts, but it seems like, well, we can just presume the driver of the car is anyone we want it to be to convict the defendant.
Well, I think it's just that there's a question of whether the driver of the car was involved in that criminal activity, and that the detective can, or an officer can, stop that car to confirm or dispel that reasonable suspicion. Where we have that the car was an instrumentality of the crime, where it's a getaway car from that assault and battery, and that the 911 caller had stated that one of the perpetrators of that assault and battery had gotten away in that car.
Is the defendant correct that the victim of the brawl or the caller who gave the license plate number did not provide any description of the brawlers other than that they were male?
The 911 caller, I'm sorry, Your Honor.
No race.
That is correct, that the 911 caller did not provide a description of the perpetrators other than to say that they were male. That is correct.
Did somebody else provide an age other than this bomber person?
Not of an age of the defendant. There was some testimony regarding a perpetrator being 28 years of age, but that is not a finding of the fact of the motion judge. That information had been discussed between the victim's grandfather and the victim, who was the grandson, but no information about the age and the race of the defendant. I'm happy to answer further questions, but if not, the Commonwealth will rest on its brief.
Seeing none, the case is submitted, and thank you both for your excellent and very helpful arguments.
Thank you very much.
We are live and on the record.
Good morning, everybody. Again, this is the December 8th, 2020 sitting of the Massachusetts Appeals Court. I am Eric Nyman. I'm sitting today with Justice Vicki Henry and Justice Kenneth Desmond. We will now call the third case on the list today, Commonwealth versus Corona, docket number 2020P0505. Counsel for each party will have 15 minutes to present their cases. I will also advise counsel that time to time you may see the judges looking side to side or away from the camera. That is not because we are not focused on your presentation. To the contrary, it is because we have computer screens around us and we are looking at the case law and the record sites simultaneously with your argument. So with that background in mind, we'll hear first from counsel for the appellant, Mr. Corona.
Thank you, Your Honors. May it please the court, Alex Conley for Mr. Corona. Mr. Corona is here on the consolidated appeal from his conviction and his motion for a new trial. The primary central issue in this case is the in-court identifications of Mr. Corona at trial and the interpretation of the trial court of Commonwealth v. Creighton. That case has clear requirements of what is needed to have an in-court identification become admissible. In this case, I would suggest to Your Honors that those requirements were not met and in-court identifications should never have been admitted. On direct appeal is the actual admission of those identifications. It's important to set the stage here as there's not one identification here at issue. There's two separate identifications that were both admitted. This involves an identification of an individual on December 28th and another separate identification of an individual on January 3rd. It's important to make sure that this distinction is clear because each identification needs to be admissible on its own. The Commonwealth seems to suggest in its brief that there's only one identification, and the trial court seemed to allude to that as well. And there's not two separate identifications, and as a result, the January 3rd identification is basically given no, there's no argument to be made of why that one was admitted, even if the 12/28 one was admissible.
Can I ask you a question in that regard? Do you characterize the January 3rd, 2018 incident as an identification procedure?
So I wouldn't characterize it that way in this sense because it wasn't a identification procedure done. It was a separate incident that needed to be for the identification of the individual on January 3rd to be admitted would have required some other basis. So I don't think it's a separate identification procedure that therefore can be tied into the December 28th event as a subsequent ID and therefore make that an admissible identification in trial. So starting with the December 28th event and the identification in court of the perpetrator of the December 28th event, Creighton is clear. You need to have either a subsequent out-of-court identification or some other good reason for its admission.
But counsel, one thing that troubles me is that this is not exactly all by itself an identification, because we do also have the license plate of the car of the person who hit the victim's car, coupled with then the elements of identification. So it's not like we're just picking this fellow out of the entire population in the area, right?
That's true, but the license plate was something the police had. The police knew the owner of it, and they ran the plates, found out who the owner was, who actually wasn't Mr. Corona, which is not in the record, but was somebody he was related to, and they used that information to get Mr. Corona. But that wasn't what the alleged victim here, Mr. Argueta Martinez, had available to him. Mr. Argueta Martinez only had his visual perceptions of the individual on both these dates. So on the December 28th incident, as far as the December 28th incident is concerned, you have to have either a subsequent out-of-court identification or some other good reason. As I just mentioned in response to Justice Nyman's question, I don't characterize the January 3rd incident as a subsequent identification.
I'm sorry to interrupt you for 1 second. Could the January 3rd incident arguably be some other good reason? So we know on the 28th, there's this accident where the victim gets in his vehicle, he follows the car that was in the accident and was able to get the license plate. That the person who was in the accident came and spoke to his window, the passenger side of the car. He wasn't able to visibly see him very well, but he did have some brief conversation with him, heard his voice. But no identification, I don't believe, was made as to that date. Is that fair to say?
Yeah, that's fair to say. I think the problem, if you try and make that January 3rd incident into good reason, is that basically what that does is it flies in the face of Creighton, because it's saying that for in-court identification to be admissible, there has to be an unequivocal, non-suggestive, proper formal identification after the initial incident. But to say that this, instead, we can use this fleeting encounter on January 3rd, where again, he didn't get a good look at the person, to take the place of what a subsequent out-of-court identification, goes against the entire idea of Creighton, that you need to have some kind of formalized identification procedure.
And so the identification, the in-court identification, was an identification of the voice. He never pointed to him and said, "That's the guy."
I believe the in-court identification was both. It said, "This is the person I saw on January 3rd, and this is the person I saw on December 28th.
After he came out from behind the whiteboard?
Correct, after the whiteboard procedure was used. I think another difference that makes this subsequent viewing or subsequent encounter or alleged encounter of the defendant not good reason is that it's subsequent to, and that's the idea for good reason brought in Creighton is prior familiarity with somebody as opposed to subsequent familiarity with somebody. And the subsequent encounters should be done formally, whether procedurally, to show that there is some kind of formal, something that's clear, non-suggestive, and shows that there is a unequivocal identification and not something prior to or not something subsequent to.
So, counsel, I understand why that might be the ideal, but where the defendant basically put himself in a one-person lineup, why should that be? Why should the Commonwealth be prohibited from using that?
Well, I think that argument presupposes that this is the same person. And if you can't presuppose this is the same person here because there's no identification to say it's the same person.
But the inferential evidence is that the defendant has come back. He had already told them, you're going to have some problems, whatever, if you report this. He's now come back and he's making comments that directly relate to the accident that happened a couple of days earlier. I mean, that's all the defendant's conduct. That has nothing to do with the victim or any state action. Would you agree with that?
I mean, I would not agree with that because, again, it presupposes that it is the defendant coming back on January 3rd. There's inferences that, sorry.
No, go ahead. I'm sorry.
There are inferences that show it could be the same person, but during the voir dire itself, he indicated he didn't even recognize the person that day on January 3rd. He thought it was the same person based on the voice. And with that combined with the fact that the brevity of both encounters, seems hard to say that that's likely the same person even to meet the admissibility standard here.
And all of that went before the jury, right?
The Mr. Arqueta Martinez's description of his encounters did go before the jury, yes.
Right, and the fact that he couldn't say for sure what he looked like, and he didn't get a good look at him, and I don't know if that by sight is necessarily him, but that's the voice that I recognize who spoke broken English or part Spanish, part English. All of that was flushed out by defense counsel. That's
correct. It was brought into trial. The jury heard all of this. I think that goes potentially to the prejudice. Certainly, it doesn't excuse the legal error in admitting them. But as far as the prejudice is concerned, still now you have the most telling identification being done in court. And this is exactly what Creighton tried to stop, is the clearly suggestive, clearly presumptive identification from being the first time this happens is in court and not prior to. Because the jury, seeing this in court for the first time, has no reason to believe that it would be inaccurate, especially where subsequent identifications based on the most recent research are less reliable than prior identifications, and it gets less and less reliable as time goes on.
It seems to me, though, that Creighton was designed to avoid the situation where someone is the victim of an attack from a stranger. They see the person for a period of a few seconds. They've never seen that person before. They've never made an identification. And the first identification comes in the courtroom where they say it's the person sitting at counsel table wearing the orange jumpsuit. I mean, it's unduly suggestive and it's unfair. This case, where there is an interaction of 3 to 4 minutes, there's a follow-up interaction a few days later of 5 minutes, where the victim here recognizes the voice of the defendant. He also, according to the victim, and I'm at transcript volume 2, pages 182 to 184, says, yes, I recognize his voice, but also he identified himself as the person that had hit me because he had a document in his hand. He said, look what you have caused. Page 183, he was wearing the same thing as before. What same thing? That cap. And at page 184, you didn't tell the police the person was wearing a baseball hat? No, I just told him that it was the same person that I had the car accident with. That strikes me as a far cry from the Creighton issues that are of concern to us.
Certainly, I would just suggest that the way he frames that is that he recognized him because of a hat and because of the paper he was holding, not because he knew the face. He didn't recognize anything but potentially the voice.
And the voice, and the context, and the inferences drawn from them.
But not the actual visual identification, which is what's the important piece here. And while, and then that's what makes that so different. And even though it is something else, again, we're presupposing that it's the same person here, based on the context and the voice and the hat, not based on identification. And as far as other cases are concerned, there's been no case I could find where a 3 to 4 minute interaction is treated differently than a 30-second interaction. The Commonwealth cites a few cases in their brief which involve half hours or multiple interactions prior to. And I think that, especially given the lack of his ability to see the individual there, show that this is nothing more than a fleeting encounter. Even if the time frame is slightly longer, there's not a good look, which is what Creighton is looking for there.
Do you think the defendant's visual appearance was the identification that was made in the courtroom, or do you think it was the defendant's voice was identified by the victim?
I believe that in the courtroom, the visual identification was made. It seemed to me that this is the same person that was on January 3rd. This is the same person, and that there's nothing indicating it was the voice as far as raised at the trial level. Just to briefly touch in the last few minutes upon the second issue with the ineffective assistance claim. Basically what this did, the identification issue was compounded given trial counsel's failures here. the first issue regarding a potential motion to suppress that could have been raised once the trial judge, who did seem to rule that it was, the January 3rd incident was an out-of-court identification procedure. If it was clearly a highly suggestive one, not caused by state action, which under Commonwealth v. Jones still can be suppressed, because if it's so highly suggestive and so unreliable as this one could be considered, it should be excluded. And finally, further compounding issues, the whiteboard procedure itself, I believe, was prejudicial to Mr. Corona here, where instead of having an identification that is just part of the direct examination of the alleged victim here, we have a stopping the direct examination, doing the cross-examine, reopening direct examination, having the trial judge ask the defendant to come out from behind the board, come sit next to the counsel and say, now, Commonwealth, ask your question about the identification. It just adds unnecessary and highly prejudicial importance to the identification there, which is again, for Creighton's purposes, to not have this be the first time this happens makes it even more of an event, I would say, which the jury would give more credence to than may be necessary otherwise. With that, unless there are any other questions, I would rest on my brief for the rest of the arguments.
Good morning, Your Honors. May it please the court, Assistant District Attorney Dara. Sorry.
That's okay. Please, you have 15 minutes. Go ahead.
Good morning, Your Honors. May it please the court, Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. The Commonwealth respectfully requests that this court affirm the denial of the defendant's motion for a new trial and affirm his convictions. Starting with the issue of the identification, the trial judge acted well within his discretion in permitting the victim to identify the defendant in court. The law in this case is clear. It comes from, as the court mentioned, Commonwealth versus Creighton, which says that where an eyewitness has not participated in an identification procedure prior to trial, an in-court identification is treated as an in-court show-up, and will be admitted into evidence only where there is good reason for its admission. Here, in determining whether there was good reason for the admission, Judge Livingston conducted a voir dire prior to trial. So the issue of the identification was the permissibility of an in-court identification was raised in motions in limine. It was decided initially by Judge Fitzpatrick on what was assumed to be the trial date. The trial then didn't occur on that date. The defendant asked Judge Livingston to reconsider Judge Fitzpatrick's order, and Judge Livingston agreed to do so. So he was considering the Commonwealth's motion to admit the in-court identification and the defendant's motion to exclude it. He conducted a careful voir dire of the victim on that day. I'd refer the court to transcript volume 2 at pages 8 to 23, applying the standard of determining whether there was good reason for the admission. During that voir dire, the victim described both incidents in which he had contact with the defendant. So the first was the December 28th, 2017 crash. He testified that he was delivering food when he was parked, a person hit his car and then drove away. He followed the car, was able to take the 2 pictures of the license plate at an intersection about 6 blocks away. He then returned to the original scene, 181 Central Street, to make his delivery, and the car that had hit him returns to the scene. The driver exits the car, comes around to his passenger side window, which is slightly ajar, and they have a 3-minute conversation. So I would disagree with my brother's characterization of this as a fleeting encounter. It was not a fleeting encounter. It was a 3-minute face-to-face conversation from a short distance away. During that time, the victim says that he could see the person's face. I direct the court to volume 2 at pages 38, that he appeared to be Hispanic. He spoke some words in Spanish and some in English. The victim was a native Spanish speaker who was assisted by an interpreter. He had a similar complexion to the victim. He was wearing some kind of hat or hood, and he told the victim that he wanted to pay for the incident in cash rather than going through insurance, and the victim insisted on going through insurance, the proper mechanism, the driver told him not to file a complaint against him. That's at volume 2, page 39. The victim then finished his delivery, returned to his restaurant, encountered a police officer there, described.
So let me stop it. We know the facts of this case really well, so why don't we cut to the chase? Let's go to the January 3rd, 2018 interaction.
So that's the January 3rd interaction. That's approximately 6 days, only 6 days between.
Let me ask you my question, which is, your brother suggests that interaction should be suppressed, at least under the principles of Commonwealth versus Jones and Commonwealth versus Johnson, a non-state action suggestive situation, for lack of a better term. Why is that not correct?
Because principles of fairness counsel against that result. First, it's the defendant's conduct that created this second identification. He comes to the victim's place of work to essentially harass and intimidate the victim further after the first incident, and essentially identifies himself as the perpetrator of the first incident, waving the papers in his hands, inferentially relating to the accident that occurred a few days earlier, saying, look what you did, asking him in a threatening manner to go outside with him. And then when he refuses, pulling out his cell phone and taking pictures with his cell phone of the victim. To prevent the victim from describing what happened on that day and describing his interactions with the defendant that day would incentivize defendants to harass and intimidate their victims after an original incident.
Let's assume that instead of threatening him and carrying the piece of paper, let's assume that someone who may look a little bit like the defendant came to the victim's place of work and just sat down in the restaurant. Did not intimidate the victim. The victim took a look over and said, wow, that's the guy. Does that invoke the principles of Jones and Johnson? The reason I ask is because your brother says that your entire analysis presupposes that that is indeed the same person. In an identification cases, we theoretically shouldn't be presupposing that to be the case. That's a question for the jury.
Well, it's not, I don't think it does presuppose that it's the same person, because the facts and circumstances, I think the facts are an important part of the analysis, certainly. So the factual scenario that Your Honor just laid out is vastly different from this one, in which the victim has a conversation where he does hear the voice for a second time, hear the language pattern for a second time, see the face for a second time, and have the connection of the paperwork saying, look what you did, look what you did. So certainly the facts are important to this analysis of whether the principles of fairness would allow it, the identification or not. Again, essentially what the defendant did is identify himself. It may be very well that but based on the December 28th interaction, the victim couldn't have made an in-court identification standing alone. Those two things, that interaction standing alone, perhaps there might not have been enough for him to do that, but you can't view them in isolation. They're two incidents that tie directly to each other through the defendant's conduct. So Judge Livingston properly considered both of the interactions. And again, I'd note that the first interaction was a 3-minute interaction at close proximity through an open car window. The second one was approximately a 5-minute interaction in a restaurant under normal lighting conditions. And I would note that the victim said he recognized the defendant when he saw him and also recognized his voice. So there was both the recognition of the features of the defendant and his voice, not one or the other. So Judge Livingston's determination that the in-court identification was supported by there was good reason for the in-court identification is fully supported by the record. There was no abuse of discretion in this case.
So if it was just the voice that the victim recognized, would we have a different situation?
I think we might have a different situation, Your Honor, because he's not hearing, as far as I recall from the record, he doesn't hear the victim's or the defendant's voice in the courtroom. So I don't know exactly, you know, if he said, I only recognize his voice, that's the only thing that I recognized, then I think that's a more difficult problem for the Commonwealth, because he's not hearing the voice at trial saying, do you recognize that voice again? So I think that might be a different outcome. But again, here there was both. He recognized, he said he recognized the defendant when he saw him and also recognized his voice. That was at the voir dire. And then he also said that he thinks at the voir dire, he said he thinks he would recognize the person if he saw him again. And indeed at trial, he said, you know, when he made the identification, he says that's him, but he looks different because he's grown a beard. So he did have, he clearly had a view of the defendant's face. Turning to the issue of ineffective assistance of counsel, the counsel was not ineffective for failing to file a motion to suppress. To show ineffectiveness for failure to file a motion to suppress, a defendant has to show that a likelihood that the motion to suppress would have been successful. Here, it's unclear what defense counsel could have moved to suppress. It's axiomatic that a victim is permitted to describe their observations, what happened to them, what they saw, what they heard. In this case, the defendant's statements that were part of that identification would be admissions of party opponents not subject to the hearsay rule. And so it's unclear what defense counsel could have moved to suppress, and therefore no likelihood that a motion to suppress any of that testimony would have been successful. Therefore, no ineffectiveness. With respect to the whiteboard procedure, defense counsel makes clear in an email that is included in the defendant's record at the defendant's appendix at 74 that she believed that the whiteboard procedure would avoid the victim looking at Mr. Corona and then describing him as he was sitting at trial counsel. So essentially, the defense counsel requested the same whiteboard procedure that had been used at the voir dire to be used at trial, so that the jury could hear the weaknesses or the defendant's perceived weaknesses of the victim's identification. So where the crux of the defense was misidentification, the whiteboard procedure allowed the Commonwealth, the defendant, to ask things like, did you notice his skin color? Do you remember the color of his coat? Do you remember what his nose or mouth area looked like? Do you remember what he was wearing at the restaurant? And the fact that he didn't provide a physical description to police. All of those were very much supportive of the defendant's defense of misidentification. So that was not, it was clearly a strategic choice as evidenced by the email and the affidavit from defense counsel, and it was not, where it supported the key themes of the defense, manifestly unreasonable when made. Unless the court has any further questions, the Commonwealth.
The defendant, he does say that this added some level of drama to the trial of this big reveal of moving the whiteboard, and that harmed the defendant. What do you say to that?
I say that certainly reasonable minds could differ. I think perhaps some trial attorneys would have elected to do that whiteboard procedure for the exact reasons that this attorney did so, and it helped her in the manners that she thought that it might. The standard isn't whether two different attorneys would do it differently. The standard is whether it was a manifestly unreasonable choice when made, and whether it prejudiced the defendant. I don't think there is a showing of prejudice here. Again, the victim, the jury was able to hear the positives and the negatives of the victim's identification, the strengths and the weaknesses of it, and clearly weren't overborne by prejudice, where they acquitted the defendant of the leaving the scene charge. So I don't think that there's any evidence of prejudice in this case. Unless the court has any further questions, the Commonwealth's content to rest on its brief.
No further questions.
And I apologize for jumping in early. Zoom, I've done a lot of it, and it remains very awkward for me. So I apologize for that early jumping of the gun.
Okay, thank you. Seeing no further questions, the case is submitted, and I want to thank you both for your excellent arguments and your helpful briefs. Thank you.
Thank you very much, Your Honors. Thank you,
Your Honor.
Madam Clerk.
We are live and on the record.
Good morning. We are continuing the December 8th, 2020 sitting of the Massachusetts Appeals Court. My name is Eric Nyman, and I'm delighted to be sitting today with Justices Vicki Henry and Kenneth Desmond. We'll now call the fourth case on our list, which is Woe versus Sex Offender Registry Board, docket number 2019 P1600. I would remind counsel for both parties that this matter is impounded, so please refrain from using names of the parties or the participants. Secondly, I said participants, I should have said the entities involved in the underlying litigation. Secondly, on occasion, counsel, you may see that we, the justices, appear to be looking away from our screens. That is not because we are not paying attention to you. To the contrary, it's because when you cite to case law or to the record, we have the record in cases for us, and we're looking at that. We are indeed paying close attention to you. So with that in mind, we will hear from counsel for the appellant.
Thank you, Your Honor. May it please the court. Ashley Green, representing Mr. Woe in today's proceedings. As the panel is well aware, my client is required to register as a level 3 high-risk offender based on one single episode of offending that occurred 11 years ago, when my client was 19 years old with a known female friend that was 15. At the time of the offense, my client suffered from bipolar disorder. He is now being treated and with medication and counseling. I would like to direct the panel to my first argument today, which the appellant is asking for a remand based on this argument exclusively. Mr. Woe's classification decision was issued, and in that decision, the hearing examiner failed to include any finding that a substantial public safety interest is served by dissemination of my client's registry information. As the panel is well aware, in 2019, in Doe 496-501, the court issued a decision requiring hearing examiners to make 3 explicit findings within their order and their final decision. And in those findings, there must be a high risk to reoffend. There must be that the offender's degree of dangerousness, if they do reoffend, is high, and that a public safety interest is realistically served by internet publication of the offender's information.
So let me stop you there. In Doe 496-501, in that somewhat infamous footnote now, the Supreme Judicial Court afforded discretion to themselves or to this court as to whether or not to remand the case for explicit findings, which begs the question, which is, how do the underlying facts of this case so clearly dictate the appropriate classification level that remand for explicit findings is not necessary, or vice versa? In other words, there seems to be no case guiding us as to when the underlying facts clearly dictate a remand to be necessary or clearly dictate that a remand is not necessary. Could you help us sort of guide us and tell us what sort of factors we should be looking for? And because it seems that there's some inconsistency thus far in applying the standards in this footnote.
Sure. I think that a review of the factors which the hearing examiner is supposed to be using in order to reach a conclusion is a great place to start for the court to review whether or not there are underlying findings. In this case, there are findings made, but there are no findings that directly implicate a community concern. In this case specifically, there is a known victim. That's something to look at. That's a big deal. If somebody is offending against stranger victims, clearly the community could be placed at risk. Another factor would be
let me push back on that though, because this was they had known each other for a couple of years, but it was sort of an accidental phone call. I didn't fully understand if it was a misdial but somehow they were strangers at one point.
Correct. At one point, they were strangers. It was a phone call made to a family friend, and the victim picked up the phone. They started talking. It was not until years later, after corresponding via telephone and on the internet, that these two met, but they had been very close friends. I mean, they were pen pals in this day and age for years. And the victim lived in Ireland and then moved here with her family, and then they met in person. So it was not a stranger victim as one would be defined by the scientific articles supporting the regulations. They knew each other for years. Another factor that goes into whether or not the community could be placed at risk would be whether it was in a public place or not. Somebody that offends, that has no regard for being caught or being, addressed by a party that could have access to the place where they're offending, that's concerning. This again was within a private residence in a private bedroom where it occurred. That's another factor. Another factor is factor 2, repetitive and compulsive, which does not apply in this case. Repetitive and compulsive is more of a complicated factor. The board's been having a hard time applying in a lot of these cases, but it states that if you are offending on multiple occasions spanning a long period of time, and you are intercepted at different periods during those offenses, and you are charged with the behavior, or you are law enforcement, if you are convicted, and then you go back and reoffend, that's concerning behavior. Compulsive is a mental analysis. That is not just that you've done it more than once. It's that there's some mental factor that's you can't control. It's compulsive. And the case law recently has talked about what compulsive means. Again, that doesn't apply in this case, which is why
the board, or could we consider though all of the restraining orders and the alleged assaults on romantic partners, that they didn't result in a sex offense, but they did result in violence against many people?
There have not been convictions for violence against women. The convictions were assault and battery charges, 2 of them. Everything else had been dismissed. The restraining orders that have been taken out against my client, again, this will go into my second argument, but it does go to the fact that this is a very complicated case, and my client is very complicated. He was very young. He was 19 years old at the time of this. He was dealing with heightened bipolar manic disorder that was completely untreated, undiagnosed, no medication. And, not to skip to my second argument, but that's why these things can't be taken piecemeal. You can't just say because this person has restraining orders against him, he therefore poses a risk to the public to sexually offend somebody. Again, these restraining orders were all taken out by girlfriends, romantic partners, not strangers on the street, not neighbors, not people that he didn't really know that well. These were relationships that he had. And clearly my client had a mental abnormality that he was not, or a mental illness that he was not addressing.
What about your client's history of either refusing or being unable to comply with the terms and conditions of probation, terms and conditions of incarceration, which seems to be continuous and ongoing? That doesn't seem to be limited based on the record that I've reviewed. It seems he's unwilling or unable to conform his conduct and is unwilling to follow authority. Isn't that a factor that would, I don't want to call it aggravating, but cuts against him in this context?
Inability to conform conduct would certainly add to a analysis of whether or not somebody should be on the registry on the internet. However, in this case in particular, I think it's important to look at Dr. Johnson's expert opinion, where she spent 5 hours with Mr. Woe. She issued a 37-page decision. Within that decision specifically, she addressed the concerns about Mr. Woe's inability to conform his conduct while he was incarcerated. And again, she directly correlates that to his bipolar disorder and his manic episodes and his attention deficit issues and his inability to focus. And if you read through a lot of the disciplinary issues that he has, They are manic episodes. Again, I'm not an expert in this, but Dr. Johnson does do an excellent job in her evaluation of explaining to the hearing examiner exactly where you can correlate his bipolar issues with certain behavioral issues. Again, I think it's important to not lose sight of the fact that the reason for the registry is to make sure that we don't have people that are offending against the community and the community is not notified. If the community were notified, it would prevent them from becoming victims. That's not the case here. There has never been an allegation that my client has tried to or threatened to offend somebody that he doesn't know in the community. This isn't a situation where my client has offended on multiple episodes. So the fact that my client has bipolar disorder and is unable to conform his conduct does not necessarily mean that he could sexually reoffend against somebody of the public. And I think it's important that we don't lose sight of the fact that it's sexually reoffending. It's not committing a trespass, the things that my client's been convicted of in the fourth, threatening to commit a crime, trespassing, even assault and battery. Those are not things that the registry is set up to prevent. It's sexual reoffending. And at that point, I would like to go into my second argument to make sure I have time for that as well. Just to close up my first argument, in this case, the hearing examiner made absolutely no findings. It wasn't that she glossed over it. There was no mention of community notification. And in that vein, this case must be remanded because I don't believe, and I think I've gone through the factors enough to show that there are underlying facts and findings in this case where this court could make a finding that even though there weren't explicit findings in the hearing examiner's decision, this court could still find that community notification is necessary. So at that a remand is warranted in this case. For my second argument, again, the hearing examiner entirely disregarded a 37-page decision that was made around the time of the hearing examiner. So it was right, it was up to date, it was accurate, it was thorough, and it was not even mentioned in the hearing examiner's discussion. With such a complicated case like this one, where my client was 19 years old, the victim was 15 years old, they had a relationship. My client was dealing with undiagnosed, untreated bipolar disorder. For the hearing examiner to not even address in her decision that there was this expert who evaluated Mr. Woe for 5 hours, who conducted a full evaluation of his mental illness, where it was, what he had been treated for.
On this one, are you talking about Dr. Chirac's report?
I'm talking about Dr. Johnson's report. She was the one that testified at the hearing, and under the rules and regulations, the board can only take the opinion of a live testimony of an expert. So I would be pointing directly to Dr. Johnson's report. However, within Dr. Johnson's report, she did directly include Dr. Chirac's report within her own report. So
in the hearing examiner's findings, at record appendix pages 68 to 70, there's a discussion of Dr. Johnson's testimony, her opinion, and I think
there is a discussion. However, what I was focusing on was the discussion where the hearing examiners usually sum up all the important facts and factors. And so within that discussion of the important facts and factors, basically what they're basing their ultimate opinion on, there was no inclusion of that expert opinion, which I find alarming in a case where clearly my client's mental health should be implicated throughout the entire discussion of where he is in terms of risk to reoffend and degree of danger, especially because there was a lot of evidence included regarding the fact that at the time my client's mental health was at issue, or his mental illness.
Wasn't it Dr. Johnson who determined that because there was this close age, that she saw it more akin to a peer-to-peer relationship or juvenile conduct than an adult and a juvenile or adult and a child victim? And doesn't the hearing examiner reject that based on the statute?
Correct. Dr. Johnson, I believe it was in volume 9 where Dr. Johnson stated that the peer-to-peer relationship in Dr. Johnson's world of the scientific articles state that because there was less than 5 years between the victim and Mr. Woe, that could be viewed as a peer-to-peer relationship. I understand that the hearing examiner just completely disregarded that and said, no, the statute says this, we're going based on the statute. I don't take any issue with the hearing examiner disregarding that specific part of the expert's opinion, because the rules are the rules. And Mr. Woe was convicted of what he was convicted of because of his age, because of the underlying sex offense. What I do take issue with is that the hearing examiner did not take into account the entire rest of the report. The fact that Dr. Johnson did a full evaluation and said that it is important to note his age at the time, and that he has come very far since that time.
And so didn't the examiner find much of Dr. Johnson's conclusions to be speculative? Didn't the examiner speak directly to that testimony?
The hearing examiner said that it was that Dr. Johnson had a theory, and I take issue with that. Dr. Johnson's opinion was not a theory, it's an expert opinion from an expert who has been fully vetted by the courts and by the board. And this was a full forensic psychological evaluation and review of the record and all the evidence that Dr. Johnson had. The index offense was committed as a result of untreated bipolar disorder. That was Dr. Johnson's opinion. That had Mr. Woe been treated, had he not been suffering from a mental illness at the time, this potentially would not have happened. And there is a reason why it hasn't happened since then. So while there could have been speculation or a theory, the hearing examiner made an error in stating that because the proof is in the record. The fact is, this happened 11 years ago. This didn't happen 2 years ago, 3 years ago. This happened 11 years ago. My client's been treated consistently, has not been convicted or charged with any subsequent sexual offense since that time.
Attorney Green, I'm going to have to stop you right there. You've exceeded your time by about a minute, but we understand your arguments. We have your brief, and we thank you for your excellent argument.
Thank you.
I'll hear from counsel for the SORB.
Thank you. Good morning. May it please the court, Thomas Doyle for the board. I would begin with the court's question as regards to what we refer to as express findings as enunciated by the SJC in 496501. Obviously, the court in that case knew that there would be hundreds of cases that would have been decided before that case came down. And as a matter of fact, this is one of them. I believe this one came down in 2018, which is the year before 496501 came down. So the court obviously gave discretion to any appellate court based on the record before it. And I think that obviously was prudent. The court asked what in the facts or the record of this case would show. They asked it both ways, whether to remand or not to remand. And I would say, I actually addressed this obviously in my brief because it was a glaring issue that I saw. So I put it in there, but I would just hone in on the fact that there were two things here that were really concerning to the SJC in 496501. One, there was a child victim. While it was a 15-year-old, it's still a child as defined by the board's regulations. And two, it was a contact offense. And those two issues were really important to the SJC when determining whether the efficacy of internet dissemination was something that should be allowed and whether public safety dictates that. And I would argue that in this case, I think you need to take into account that she was not only a child, she was a foreign child. I mean, I understand she spoke English. She was apparently of Irish citizenry, but maybe she wasn't used to the ways of the United States. That may be speculation. But the fact also that it was a contact offense is even more implicating of why your discretion should not be invoked to remand this. It wasn't just a single contact. It was 3 counts of rape and abuse, 3 instances of penetration, and then 2 other counts of indecent assault and battery on a person over 14.
Mr. Doyle, I would love to be able to ask you a question. So if you could just slow down a little bit, please. Are you taking the position that anytime a case involves a victim under the age of 16 in a contact offense, that constitutes underlying facts that so clearly dictate the appropriate classification level such that a remand is not necessary?
No, I would not say that's a hard and fast rule. I am mentioning in this case specifically where the SJC mentioned the things to look at to not exercise your discretion that are, I guess you would say, the most important are if it's a child victim or a contact offense, because they say that a contact offending is more dangerous than a non-contact offending. And I'm sorry, Your Honor.
So how do we evaluate that though on the appellate record where we do also have, I don't think we should use the 11 years since any sex offense, but I think at the time of the hearing, certainly 8 or 9 years without any further alleged sex offenses. And also we do have the mental health issue and he now is in treatment. So what do we do with that?
That would bring me to my next point. I would say that those are the most important things, the contact offense and the child victim. But then you look at the totality of the evidence. It's the board's position, and I think that's been backed up by the SJC, is you look at this from the time of the hearing, the administrative hearing, which was November of 2017. The gentleman at that point was in his late 20s. He committed the offense when he was 19. He kept committing crimes as he aged. He was convicted of a 209A violation, which goes towards hostility against women. He was convicted of, I think, a couple of other different crimes.
So counsel, he definitely, well, he at least had a couple of convictions and he certainly had several restraining orders taken out. But defense counsel argues, or excuse me, Mr. Woe's counsel argues that they weren't sex offenses, and that's really what this is about. Are you saying that just committing other crimes would qualify for internet dissemination, or do they need to be sex offenses?
Right. Well, as I said, you need to look at the totality of the record. The board's factors, all the board's 38 factors, encompass a whole range of activity. As counsel stated when she was mentioning all the different factors that didn't apply, which is not evidence and it's not mitigating or aggravating, you do have a situation where there are risk elevating factors. And as I noted in my brief, several of them apply here. He couldn't control his behavior while he was in a setting where he was while he was incarcerated. He had multiple D reports. He's violated probation, hostility towards women, the level of physical contact. Yes, he hasn't committed another sex offense, but that's not the standard. The standard is, what is his risk to reoffend and degree of dangerousness based upon the totality of the record, where the hearing examiner took the evidence and applied the factors as she saw fit and gave them the appropriate weight. Yes, there's been no new sex offense. However, that's, as I said, that's the absence of evidence. The fact that there's been no new sex offense is irrelevant. What is the record before the hearing examiner and before this court? I would just note, even though counsel said she wouldn't take into consideration the peer-to-peer thing, the peer-to-peer relationship, under Factor 3, it does say that if the difference in age between the offender and the victim is 5 years or less, which is the case here, and there is evidence of a consensual, although statutorily criminal, sexual act, the board shall give limited weight to Factor 3. That is not the case here, because there was evidence that it was not consensual. So I just wanted to point that out to the court.
So I think I understand you. You're basically saying that this regulatory position is, for want of a better expression, a Romeo and Juliet provision, but it does not operate if there was no consent.
I wouldn't say it was a Romeo and Juliet. I actually think his behavior was predatory. I mean, he was asking her when they were in communication, when she was in Ireland, would she perform oral sex on him? So I don't think it was a Romeo and Juliet. I think he took advantage of a younger foreign girl. And there was evidence in the record that he apparently stated to her when he started the sexual assault that you're going to do what I tell you. So I would not acquiesce that this is a Romeo and Juliet.
No, not that he was, that regulation is.
Yes, I agree that regulation is put in there to take into account if a 15-year-old girl and her 18-year-old boyfriend had consensual sex, but other the fact that it was statutorily a crime, we would give less weight to that. But that is not the situation here.
So you say that, or you put some stock in the fact that she was not an American national. Neither was he, right?
That's a good question, Your Honor. From what I remember reading, I thought he was born and raised in the United States. He might not have been. I don't know.
And you say that, it's kind of neither here nor there that he hadn't committed any other sexual offenses. But if he had, that'd be the first thing you'd be telling us, right?
You're absolutely right, Your Honor. But based on this record, as I said, in general, the absence of evidence is not aggravating or mitigating, and that's not the standard. The standard is, what is his risk to reoffense and degree of danger based on the evidence at the hearing? The fact that there was no new sex offense, and obviously that helps him.
Well, that's true. But is it so clear on this record that the information needs to be publicly disseminated? I mean, I understand you can make the argument, but is it so clear on this record?
I would agree. I would argue that it is because of his overall behavior as an adult, that he sexually assaulted multiple times in one sitting a child victim, which with contact offenses, multiple contact offenses. And I think that's what the SJC said is some of the most important things to take into consideration when the court decides whether to exercise its discretion. As far as the expert, I think it's important to note that when it comes down to it in her multiple page report, she talks about the reasons why the petitioner committed this offense. And she says it was because of his age, even though he was 19, and his untreated mental health issues. Well, in relation to the age, the factor was clear. An adult is anyone over 18. That was the case here. So the hearing examiner didn't give that any weight. Now, as far as the mental health issues, it seems apparent on the record that that was the case. But I think something else that needs to be pointed out, well, there were two things. One is his compliance with his mental health medication and things of that nature. And if you look some of the examples on the cross-examination of the witness, because she said, well, now that his mental health is going to be treated, his risk is much, much lower. But in volume 9 on 69, she was asked, did you agree that the petitioner lied to an evaluator? She said, yes. The same volume, page 70, she was asked about his meds. If he lies, how do you know he'll take his meds? And she said, it's possible he won't take his meds. Volume 971, she agreed that at the time of the hearing, he was not maintaining his medication. She also agreed when asked if he would forget to take his medications on volume 9, 71, 72. She said yes, that he did forget to take his meds. When she was asked if there was any evidence he was taking meds for his bipolar, again, she said not taking the meds. And that was at volume 972. And lastly,
did the hearing examiner rely on that?
I think to an extent, I don't think she, as much as I'm particularly pointing it out, but I think she, in her regard, she was saying it was speculative. I can't say what was in her mind, but obviously she was there and read and heard this testimony. The doctor's saying, well, his mental health now has been diagnosed. He is on sufficient treatment that lowers his risk, but yet you have all this thing which she agrees he's lied to evaluators. He's not taking his meds. He's forgot to take his meds. And there was no probation condition once he was released to take his meds. So I think the other thing I wanted to address as far as the expert's report is she seems to be hung up on why he committed this offense. And the board's mission is to determine whether they will commit another one. What is his risk and danger? And that is not something I believe the expert in her report or her testimony seems to address at all. She talks about why he did it, because he was 7, because he was 19, and he had untreated mental health issues. So I would argue that.
We really only hear these cases when the board has determined that the person will commit an offense, right? So
there has to be a conviction, yes.
Yeah, but we only see that slice. So I take it you are representing that sometimes the board concludes they won't commit another offense. In other words, 100% of what we see is a classification of a level 2 or 3. We don't have any other world.
Okay.
So is there another world?
I'm not quite sure if I understand your question, Your Honor. The question for the board and its mandate, and I actually, because I'm so used to doing this, I actually took a minute to look it up in the statute, and we actually have to determine, well, it says the board shall promulgate guidelines for determining the level of risk and danger posed to the public and shall provide for 3 levels of notification depending on such risk and danger posed to the public. There's nothing in that mandate setting up the board to talk about why they committed the sex offense. The mission is whether they are at a risk, and if they are, what degree of danger to commit another one. And what I'm arguing is the expert was all hung up on why he did it. That may be probative to some extent. Maybe his mental health issues was undiagnosed and he's on medication, but the record has the support in the record to show that, yeah, he might be on medication and may be diagnosed, but there's a viable argument to be made that he's not going to be on probation condition to take his meds. Nobody's going to be supervising him. He's lying to evaluators. He's not on meds when he's supposed to be. And I think that goes towards...
At a rebuttal, she would probably argue to you that if we knew what the why was, then we would have a better idea of whether it will happen again. What would you say to that?
Yes, if I know why somebody committed an offense, that may be, like I said, probative of whether he would commit another one. But the board's mission is to determine whether he will commit another. What is his risk to commit another sex offense? And if what that risk is, what is the danger to the public? Why he committed the offense, she's saying because of age or mental health issue. I don't want to repeat myself, but as I just said, the record is replete with, okay, well, her argument, the expert's argument for a low risk is his age, which we dealt with, and his mental health issues. But then, as I just said in that cross-examination, he's known to be a liar. She admitted it. He's not taking his meds when he's supposed to, and he's at no probation conditions to ensure that he takes his meds. So how does that lower his risk? That would be my argument, Your Honor. Unless there were any other questions, I would rest on my memo.
Seeing none, case is submitted. Thank you both. Very helpful arguments and very good briefing. Thank you.
We are live and on the record.
Good morning. Calling the next case for the December 8th, 2020 sitting of the Massachusetts Appeals Court. It is Department of Children and Families versus Father and Another, docket number 2020P 0431. A couple of things for counsel to keep in mind. Number one, this case is impounded, so please conduct yourselves accordingly. Number two, from time to time, you may see the judges on the panel looking downward or side to side. That is not because we are not paying attention to your important arguments. To the contrary, it is because we are viewing either the record or the cases to which you cite simultaneously with your argument. So with that in mind, we will hear first for Attorney Butler, counsel for the father.
Good morning, Your Honor. Deborah Sirotkin Butler for the father in this matter. And I would like to draw the court's attention first to a black letter law issue, namely General Law, Chapter 210, Section 2, which states in pertinent part, a degree of adoption shall not be made except as provided in this chapter without the written consent of the child to be adopted if above the age of 12. Nowhere in this record does such consent appear for the oldest child, by first name only, Nicholas. And the social worker did not know about this and was unaware, and see the notation at transcript page 345. At this point in time, the other two children are now also 12. I will point out that in another case, adoption of Zach, this issue was dealt with by the judge meeting with the children in chambers and assuring that they had private consultations and that General Law 210, Section 2 was complied with. Additionally,
the department has said, or the children, both the department and the children basically say, well, there are express statements of where the children want to live and that was admissible and that the children actually brought this forward and that's enough. Why are they wrong?
The law is on the books for a reason. Adults can make pro-offers, say that children made out-of-court statements, and these out-of-court statements are not verified. I should point out that in the record, the boys were always excited to see their father. They ran right up to him, they jumped on him, they hugged him, they kissed him. Look at transcript page 271. They immediately just jumped on him and hugged, transcript 306 to 307. In the court report, what the court investigator states the children said is that they love their mother and father, they want to see both of them, and they love the people they've been living with for now probably close to 5 years. But there is no statement in the court investigation or elsewhere that any of these children said they wanted to be adopted, that it was explained to them what adoption meant, or that there would be not even a finding about the bond or any visitation for them with their father.
Let me ask you this question. Does it matter that at record appendix page 77, there's a finding that the children signed off on the permanency goal? Why is that not sufficient to indicate compliance with chapter 210, section 2? And I assume you're going to say that's plain language, but go ahead.
I'm happy to answer that. The children didn't, their attorney did. There is no record that their attorney even told them that he or she had done so. I'm not remembering whether child's counsel was male or female, but that was the equivalent of a pro-offer.
So were we to agree with you, what remedy would you suggest?
That one, an adoption cannot be at this point finalized, that there should be some type of remand with an independent investigator who meets with the child privately. These are now 13, 14, and 12-year-olds, and explains what adoption is, and has the actual form, and the person conducting the interview could also be a notary, or there could be a separate notary.
Why should it be an independent investigator rather than the child's attorney?
To avoid placing the child's attorney in a conflict role, since you can't be both an attorney and a witness. That person who conducted the interview and might be in the position of testifying about it, if they were the attorney, would be in a conflict position and could be stricken from the case.
That's your suggestion, correct? You don't come, that doesn't stem from any statutory language or any precedent.
It stems from the rules of practice and procedure promulgated by the SJC, that an attorney cannot also be in the position of being a witness.
Let me rephrase my question, meaning your suggestion that an independent investigator should be used stems from, again, it's your suggestion, that does not stem from statutory authority or SJC or appeals court precedent.
I think it's in accordance with the recorder's comments to General Law 210 and its amendments, Your Honor. And also to the guidance in representing clients with a disability promulgated again, by the SJC.
So you're arguing that in every single case with a child that's over age 12, the child would have an attorney and the court would need to appoint an independent investigator to get this statement?
If the position of the department is that an adoption should occur, that step would have to occur for the adoption to be in compliance with law, whether it happened before trial or after trial as part of completing an adoption. Here, there is simply nothing in the record where any one of these children directly states that they want to be adopted and they understand what termination of their father's and mother's rights would imply and lead to. And that's a problem.
So for the two younger children, 210-2 doesn't apply.
Well, at this point it does. But
at the time of the hearing, did it?
At the time of the hearing, no, but no adoption has been finalized.
So
and Gender Ad 210 is uncompromising that you cannot finalize an adoption with the child who's over the age of 12 without having this done to be sure that the law is complied with and this actually is the child's will and rights. I should point out that closed adoptions are a kind of fiction at best anyway. 12-year-olds know who their parents are. Children aren't sacks of groceries. You can't pick them up in one family, put them down in another and say, your ethnic heritage, your traditions, your memories are all erased now. It's not like the Men in Black. And unfortunately, I and many other attorneys have been in the position of representing children, now teenagers, who came out of adoptions that, frankly, though they were finalized, disrupted. And when you put a child in a position of identity conflict, when they never really understood how things were going to play out, I'm deeply concerned that this judge, whether there became an animus issue or for some other reason, never did the findings required by adoption of John.
So you're saying though that this had to happen as part of this procedure and it's not enough if it happens later?
Your Honor, unfortunately, the adoption statute and the care and protection statute have a gray area. I helped brief and argue guardianship of Kelvin. Guardianship of Kelvin dealt with a similar gray area where the statute was silent about what should be the standard for removal of a guardian. And so all the attorneys involved worked together to propose what the standard should be, and it was adopted by this court. I think there's a statutory problem here where when the goal is adoption and the child is over a certain age, there should be clear guidance to the bench and bar how to handle that. And I am making the suggestion as to what could constitute best practice, eliminate the conflict, and not cast a sort of shadow of title upon an adoption that might be agreeable to all parties. I also point out here,
I understand you're saying that if we don't have the judge do it at this stage, and we were to say affirm here, and then the child said, we would have terminated rights on the one hand, and the child says, I don't want to be adopted, then the child would just not have a legal parent. Is that your concern?
It's one of them.
It's sort
It's
of a,
also a concern that it stresses the adoption and it could be more likely to disrupt. And that it results, as I said, from a place where statutes kind of have a hole, just as they did in Kelvin. I'm also concerned that mother was subject to solid discrimination of the very sort that was just the topic or gravamen of a consent decree in Boston. She has an IQ of 70. The department placed her children 3.5 hours away from her, knowing that she didn't drive, doesn't have a driver's license, and when
so counsel, but let's pause on that issue for a moment. It's correct that the father did not seek custody of his children at the second trial, and he's not doing so now, right?
It's more nuanced than that. At the time of the second trial, there hadn't been a null prosecution on a criminal case against him. In the record, in the appendix at page A74, that null prosecution is now part of the record. But at the time of the trial, he was concerned that he faced incarceration. He knew mother to be a competent parent, and she had been the primary caregiver prior to the time when he was.
But even now, he's not seeking that he have the children, right?
Your Honor, he would be overjoyed to have the children. It was his belief that the court would never give them to him, and that were the children placed with mother, potentially he would have reasonable parenting time.
Is he now seeking?
The judge didn't even deal with the bond and gave mother parenting time and father none is deeply concerning.
So mother didn't appeal. Is he now seeking custody of the children? Yes or no?
He would gladly accept custody of the children, yes.
That's not the question. Is he now seeking custody of the children?
Is he now, I tried to answer that as best I could.
Can you answer it yes or no?
Could I state his position as, yes, he would seek custody of the children? Yes, I would.
Yes, he would seek custody.
Yes.
But he hasn't so far.
He couldn't. His rights were terminated. He was given no parenting time. What happens in the grade time when there's a termination and an appeal is the department gives you no contact, gives your attorney no information, whether it's trial or appeal. And in fact, as soon as in this case, the goal became adoption, there were no services, not even sham, not even window dressing, not even hollow. And the social worker said as much.
Expired, but I have one final question, and I'll check with the panel as well to see if they do. With respect to your Chapter 210, Section 2 argument, does your client have standing to make that argument?
Your Honor, issues of subject matter jurisdiction can always be adjudicated by the court. I draw your attention to United States versus Ruiz. This is a subject matter jurisdiction issue.
Okay. Let me see if Justice Desmond, Justice Henry, any further questions?
No, thank you.
Thank you very much for your argument. Very helpful.
Thank you, Your Honors.
We will hear now from counsel for, I believe, DCF first.
May it please the court, Jeremy Bayless for the Department of Children and Families. This is a case where the father in the months and time preceding the trial made very little effort to remedy his parental deficiencies. While his parental rights were not terminated following the first trial, in the intervening period, he moved to Tennessee away from his children. He made no concerted effort to visit them regularly, seeing them only 3 times in the time shortly before trial. And he began to affirmatively reject the idea of participating in services. He said he would not participate in anger management because anger management services, according to him, do not help with anger problems. He also testified that he would not participate in services to spite the department.
What do you say in direct response to 210 section 2 about the 12-year-old's consent?
That is not an issue that is relevant to the termination decree. Parental rights are terminated all the time with children where the plan is not adoption. Parental rights can be terminated, the child can be put in a guardianship. Parental rights can be terminated and the child can, we prefer this not to happen, but can reach the age of 18 and then sign out of the department services or sign in for additional services. The child's consent to an adoption is not a prerequisite of the termination of the parental rights. And the statute actually states that, and my sister acknowledged, that the child's consent to adoption is necessary to finalize the adoption. This is not an appeal from an adoption finalization. That will happen later in front of an adoption judge. At that time,
what about her argument that we've basically created this hole where you terminate these rights, and it does seem fairly clear that children are excited to see the father. You've ended a legal relationship with them, and then he may not have a legal relationship with another parent. He may not get another legal parent if he objects.
Well, this is a bit of a difficult question because in this case, it's just factually not true. The children have sought the termination of father's parental rights. They brought the proceedings to terminate his rights. They're here today.
Counsel, we hear cases all the time where the Commonwealth argues to us that we have to follow every statute and that the public has to follow every statute. And you sound like you're arguing, well, we don't have to follow the statute, or at least we don't have to follow it now. And I'm a big believer in what sauce for the goose is sauce for the gander, right? So are you trying to tell us that you don't have to comply with this?
No, Your Honor. I was specifically addressing your concern about these children being made legal orphans against their wishes. That's factually untrue. But
yes, but we have a way that we're supposed to know it's factually untrue, which is that you have written consent of the child, which we don't have, at least for the child who was age eligible at the time, right?
That's correct. But that written consent isn't necessary until the adoption is finalized. We don't finalize the adoptions.
So you do see the whole here, right?
Yeah, there is a period of time where a judge can approve adoption is the plan for the children before and the children have however long it takes generally for the appeal to conclude before there would be adoption proceedings. But if we're following the statute strictly, that approval is only necessary for the adoption to be finalized, which means it can happen, as my sister agreed in her argument just now, that can happen at trial or it can happen after trial before the adoption is finalized. It creates the potentiality for an awkward circumstance with children and with the family. But that's where it really needs to come down to the specific facts of the case. Creating a de facto rule that the adoption finalization requirements need to be met at times a year or more before the adoption is finalized is unnecessary.
So let's say that an attorney has a child client who does not want to have his parents' rights terminated. Does the child's attorney then have an obligation to come forward and say, we can't, my client doesn't want this and we can't comply with this section. So if the court terminates, then my child's may not give his consent later to adoption. In other words, shouldn't we know before the termination of parental rights what the child's position is?
There's a difference, Your Honor, between knowing what the child's position is and having the child make a written statement supporting adoption. There is no evidence in this record that the child's attorneys were violating their professional obligations to represent the wishes of their child. We have had repeated statements from the child that they want the parental rights terminated. They want this
I
adoption.
understand that, counsel, but there's a reason why, for example, we have witnesses take an oath, and I can assure you after decades of practice that something magical happens when somebody swears to something, right? And there's a reason why the law requires writings.
Yes.
Okay, and it's different. So if we wait, what's the reason? Why would we all recognize that there's a potential hole here. So why should we wait? Why is the best policy to wait rather than just say, let's cover this ground now so we know what we're doing?
The best, father's argument is functioning as if there is a requirement for the termination of parental rights, for a black letter law requirement for termination to happen, that the child have in writing approved an adoption that won't happen for a year or longer. That mandated response is not in the law. As a matter of practice, an additional reason why it is possibly best to wait is that children's positions change. What a child might sign off to at the time of trial may not be the case by the time the adoption comes around. The identified pre-adoptive parents may no longer even be an option by that time. So the best time to make sure, if we want to get it right, that a child wants to be adopted is when they have the full information of the actual time of adoption. And the concerns that a child may not understand their legal rights or may not want to proceed with termination knowing their different options are to be addressed by the assistance of competent counsel. And if there was an indication that counsel was arguing against their client's interests, that might be a different set of facts to be addressed either here.
Otherwise said, is your argument that 210 Section 2 has not been violated yet because no decree of adoption has formally issued?
Yes, Your Honor. This is, to the extent my sister is arguing it, not yet right.
My follow-up, can you address my question on standing?
Yes, Your Honor. It depends, which is not very helpful, I understand.
How about in this case?
In this case, at this point in time, father can make the argument. But once his parental rights are terminated, he no longer has a say, which is appropriate because this is designed to protect the children's interest and ensure that the children are going somewhere after their parental rights, after father's parental rights have been terminated, that they are willing to live.
Do you agree with your sister's argument that this aspect of 210.2 is jurisdictional?
Yes. And if there are no further questions, I see my time is winding down, and I can cede the rest of my time to my brother.
Check with Justice Desmond, Justice Henry.
All set.
Okay.
Thank you, Your Honor.
Attorney Beal.
Good afternoon. May it please the court. Eric Beal on behalf of the appellate children. Picking up the thread in answer to your question, Justice Nyman, as argued in my brief, father lacks standing to raise the substantive rights of the oldest brother, Nicholas. And I cited for that proposition a case from this court, Care and Protection of Xantha. It's an unpublished decision. But in that case, the father made essentially the same argument that father makes here, that the judge was required to consult with a 15-year-old child in an age-appropriate manner. And this court rejected that argument, saying that those rights belong to the child, and father has no standing to assert those rights. Related to Chapter 210, Section 2, the statutory language is plain that that provision applies only to a decree of adoption. This appeal, as my brother stated, is not from a decree of adoption. It's from a decree rather terminating parental rights. And so Section 2, Chapter 210 really has no relevance at this time to this appeal. Related to the actual evidence in this case, there's very, very substantial evidence of unfitness on the father in this case. As the trial court found, and these findings were uncontested on appeal, he lacked stable housing. There was evidence of violence against the family and a substantial criminal history. And he also, at some point, just flatly refused to participate in services, as my brother from DCF pointed out. And then to top it off, father actually left the state and a little more from a year before trial, and was only able to visit the children 3 or 4 times a year, and hadn't seen the children before trial for, I believe, about 3 months. So again, very substantial evidence of unfitness. And I think that evidence also supports the court's finding that it was in the best interest of the children to terminate his parental rights. As to mother's fitness, and I argue in my brief that as with the oldest child's rights around adoption, father also lacks standing to argue mother's fitness, and rely on the case of adoption of Paula, which is SJC case 420 Mass 716, and then another unpublished decision from this court, adoption of Walt from 2014. In Walt, the father made many arguments in that case related to the mother's fitness. And this court, citing adoption of Paula, say we need not consider his challenges as the father is without standing to argue mother's fitness. And in addition, in guardianship of Tara, which I think is similar to the case at bar, this court found that there was no relief that the court could give. The facts in that case were it was a guardianship proceeding where a grandmother had sought guardianship. That guardianship petition was denied. The children and DCF had appeals. The grandmother did not appeal, and this court decided that there was no practical relief that it could order in that case because the grandmother was no longer contesting the denial of the guardianship. And similarly, in this case, the mother has not appealed from the termination of her parental rights. So even if this court were to remand the matter for further proceedings, mother's rights have already been terminated. She has no further stake in this case. And so for that additional reason, this father lacks standing to argue mother's rights in this case. I would just in the few seconds I have left, there was an issue related to some hearsay statements of the children in a CASA report. It's the court-appointed special advocate report. The children did state in that report that they would like to stay where they were in the pre-adoptive home, and that they had a desire to live with their foster dads and have visits with their mother. In the transcript at pages 33 and 34, counsel for the parents did say they had drafted motions limine to exclude those statements. The court said that it wouldn't take them, and as I argue in my brief, it would be entirely appropriate for the court not to accept those statements for the truth of the matter asserted, but to accept them as evidence of the children's state of mind, which is relevant to the underlying proceeding. I see my time has expired. If there are no further questions, I'll rest on my brief.
Okay, seeing none, that ends this case. I want to thank all counsel for their vigorous, excellent advocacy in the cases submitted.
We are live and on the record.
Good afternoon. This is the final case for the December 8th, 2020 sitting of the Massachusetts Appeals Court. I'm Eric Nyman, sitting today with Justices Vicki Henry and Kenneth Desmond. Our last case is docket 2019 P1787, Sanovage versus Chavis, and we will hear from Attorney Remillard.
Good afternoon, Your Honors. May it please the court. My name is Maria Remillard, and I represent Stacia Chavez in this matter. A probate judge enjoys discretion in rendering custody decisions. However, that discretion is not unlimited. Statutes guide the court's decisions, and a parent's constitutional rights cannot simply be disregarded with vague statements about the best interest of the child. Now, while the trend has been to award shared custody to parents, it should not be at the expense of the rights we hold sacred, such as the freedom of speech and a parent's right to the care, custody, and control of their child. When a court's decision fails to follow statutory directives and unjustly infringes upon a parent's rights, those portions of the judgment must be vacated.
So Attorney Remillard, there was a stipulation offered in the trial portion of this case, right?
Yes, Your Honor. Well, excuse me. There was a temporary stipulation for temporary orders. Yes, Your Honor.
And it seems to me that much of what was agreed to by the parties in the stipulation, the judge tried to adopt in his order. Would you agree with that?
A portion of what they stipulated for temporary orders, yes, were incorporated into the decision. However,
and that portion included many of the things that you seem to complain of today, as far as statements that maybe can be made in the child's presence, and how to be respectful and courteous about the other's parent in the child's presence. All of those things seem to have been reduced to writing by the parties themselves. Would you agree that that portion is in the judge's findings?
those portions were reduced to writing in a temporary or in a stipulation for temporary orders, correct, but not for a stipulation to be incorporated into a judgment, which is not unusual in these kinds of cases, because when these judges here and these parties go in at the temporary order stage, we typically have families in crisis where there's a Band-Aid, there's a stopgap, and these parties are informed that these aren't going to be part of a judgment. These are temporary measures, and hence the stipulation for temporary orders. And so I do think that there's a big distinction between parties stipulating for temporary orders prior to discovery, prior to a trial on the merits, or even a meaningful pretrial, and stipulating to these types of provisions with the intent to be incorporated into a judgment of the court.
So when there's a temporary order and it's violated, then what would happen in those circumstances?
If it's a temporary order, well, first, I think the provisions are too vague to be enforced, because for, let's say that there's a provision that is violated, then the remedy is typically the complaining party would file a complaint for contempt, and then there would need to be a showing by clear and convincing evidence that there is a clear and unequivocal order and an equally clear and undoubted disobedience. So I'm not quite sure you could reach that hurdle, but even if you could, the distinction, it's not exactly clear, because the Shack case had been, was decided subsequent to my briefing in this case. And the Shack case dealt with these infringements on parents' constitutional right to freedom of speech. However, the court noted that parents can make agreements with respect to those provisions. So in the temporary order stage prior to judgment, those non-vague provisions could potentially result in a contempt finding against the violating parent. So with respect to the court's judgment regarding the parenting plan, as the parties were never married, the provisions of 209C apply. The court must make a finding that the parties can communicate, or there must be a written agreement with respect to the joint custody. And there needs to be a finding by the court and that this joint custody is in the child's best interest. While here we have a judge who granted the parties joint legal custody of the child with mother to have custody, this award of physical custody was not in conformity with the directives of the statutes and case law. In addition to the finding.
I'm sorry, are you talking about the visitation schedule right now?
Yes, I can go further back with respect to the constitutional arguments if you.
No, I have a couple of very specific questions about the schedule, which is, and I hope I'm not pulling you off of your argument here, but at record appendix pages, it's volume 1, pages 50 to 51, there are the probation department recommendations regarding custody and parenting time. Had the judge accepted that recommendation, would he have abused his discretion?
No, because the probation's recommendations, that provision for every other weekend from Friday evening to Monday morning and an overnight beginning on Tuesday at 5:45 to the next morning or 8 a.m. is.
So the one distinction then between the probation recommendation and the judge's order was the judge ordered, I think, an additional night every other week so that the nights were divided evenly. Is that correct?
The distinction is that, yes, all the nights are divided equally. So the parents, each of the parents have an equal number of overnights and nearly equal parenting time.
Okay, well, I guess I have my first question then is, by adding that one additional night every other week, you're saying that in and of itself constitutes an abuse of discretion then?
Yes, Your Honor, and it's not just one night, because if you look at the suggestion of the probation department, it isn't even a 24-hour basis for the Tuesday overnights. We're talking approximately 12 hours. Is the father would get the child Tuesday at 5:45 p.m. and drop off the child at 8 a.m. If there's no school, or at the school at the time of school. Where the judge issued his parenting plan, we're looking at Tuesday at 5:45 until Thursday drop off in the morning. And so it's a significant amount of time, particularly when you look at some of the issues that the child was having initially, and such as picking her eyebrows, crying prior to parenting time, and refusing parenting time as well.
So he added that one Wednesday night.
He extended he extended the Wednesday parenting time through the day, added the Wednesday overnight. Yes, Your Honor. And so by doing that, when you look at the overnights, and there may be a discrepancy of a couple hours where the child is with my client more, it's effectively what he did was he transformed the award of physical custody from the mother and transformed it into a shared physical custody arrangement, which is very concerning because the statute instructs that, and case law instructs, and that there needs to be a finding that these parties can communicate and co-parent, and there's a history of joint decision making. In here, there is no history of joint decision making, and during trial and even in the findings, there's explicit findings indicating that the parties can't communicate well.
Let me ask you two questions. One, have you worked out, I know the nights work out evenly, the overnights. Have you worked out the math on the time with the mother versus the father? Does it work out to something like 62% of the time to 38% of the time over a 2-week period? Is that about right?
I did not work out the math, but I think that the child support guidelines are instructive on this, and I'll tell you why. So for child support guidelines, if a parent is to get full child support and presumed to be the primary parent, that parent would have the child 2/3 of the time, and the non-custodial is assumed to have approximately 1/3 of the time. And so I think that, you know, that tends to be a rule of thumb as far as looking at, okay, is this a shared parenting plan, or is this not a parenting, a sole parenting plan?
As I worked out the math, and I, you know, there's a reason I'm in the law and not a mathematician, but as I worked out the math, it struck me that the parenting time was closer to 2/3, 1/3 than to 50-50, actually. But I could be mistaken.
I didn't work out the math, so I can't really cite to that. However,
I was also confused by this point. So they have equal overnights, but the time is still more in her favor because on days where there's no school, the drop off is at 8 in the morning. Is that what it is?
no, the drop off time in the morning, it's just, I was, for the sake of clarity, I was trying to make it clear that, you know, if it isn't 8 o'clock, then it would be drop off time at the school. I don't think that that's a huge amount, although during the summer and during non-school periods, certainly there's additional time on those Wednesdays, on the time that the child doesn't get to see her mother.
Now, your argument with regard to 209C Section 10 seems to be that the parents have a history of poor communication, and therefore, in your view, they don't have the ability, that's the key word in the statute, the ability to communicate and plan with each other. But one doesn't necessarily follow from the other, does it?
As far as the ability?
Correct. You can have a poor history of communicating, but it's up to the judge to determine whether or not they have the ability to communicate and plan. And that's why the judge ostensibly implemented very rigid guidelines to obligate them to communicate better. And that's why he puts so much detail into it. At least that's how I read the record.
I didn't read the judge's decision as showing that there was an ability. In fact, I read the decision showing that there is an inability to communicate, and they have trouble making joint decisions with respect to this child. And given that history and the issues that they have, custody to one parent would have been appropriate. The Carr case indicates where the relationship is non-existent, contentious, and dysfunctional, custody should be given to one parent. We have here two individuals who don't agree on much. They don't agree on religion. They don't agree with respect to whether this child who was having issues should have therapy. We're talking about major decisions that they can't agree on. And so just issuing a judgment and saying, hey, parties, if you don't agree, keep coming back, I think that it's sort of welcoming and encouraging these high conflict situations as opposed to following the statutory directives and this court's prior decisions. With respect to some of the provisions in the judgment regarding the care, custody, and control of the child, the trial judge should not have been inserting his own views on how to raise a child for those of a fit parent. And those provisions violate my client's constitutional rights, actually both of these parents' constitutional rights, to decide how to raise their child. Where there is a fit.
Counsel, what provisions specifically do you think should be struck?
There are a lot of them, and unfortunately,
I'm asking because otherwise you leave us to wander around and figure it out.
So for example, any of the provisions that relate to that infringes upon the party's freedom of speech should be stricken. Any provisions requiring the parties to use the child's legal name for all public and private purposes, provisions regarding requiring the parties to monitor this child's social media postings at all time and restricting any postings. While some of these provisions make sense as a parent, it's not sustainable for a court to legislate that. Provisions requiring the parties to be personally present in any and all exchanges need to be vacated. I thought I had fully listed as best.
Sorry to interrupt you, Attorney Remelot. Your time has expired about a minute ago, but I just want to check with the panel to see if anyone has any additional questions for you. No, I can assure we have read your brief and the record, and we will take another look at it. And thank you very much for your excellent presentation.
Thank you very much.
And that concludes our session.